Hello everyone, welcome to Kickstart Privacy. Ashik this side. In today's video, let's understand one of the basic and important principle in data privacy, which is lawfulness, and which lawful basis applies for processing personal data and sensitive personal data with some examples. Okay. As a privacy professional, it is very important to understand the usage of different lawful bases in a company before starting or initiating any data processing activities. And these are the topics I'm going to cover today: the introduction, the importance of lawful data processing, and the brief overview of each lawful basis under the GDPR, and the processing of sensitive personal data, and finally the conclusion. Introduction. In the digital age where data drives decisions and personal information is more accessible than ever, right? It is essential to ensure that this data is processed responsibly. This is not only to protect businesses and organizations from legal repercussions, but more importantly, to safeguard the fundamental rights and freedom of individuals. Okay, why this lawful basis of processing is so important? Because the number one is the trust and confidence. In an era marked by numerous data breaches and misuses, processing data lawfully instills trust in individuals. When people know their data is handled correctly, they are more likely to engage with services and products. Second point, reduced risk. Lawful data processing significantly mitigates the risk associated with data breaches or misuse. Non-compliance can lead to hefty fines and damage to reputation. The third point, ethical obligation. Beyond legal compliance, there is an ethical imperative. Respecting individuals' data is respecting their autonomy, privacy, and dignity. A small brief about what lawful basis is. Lawful basis refers to the explanation of the legal justifications or reasons that entities like companies or organization can rely upon to process personal data under the data protection laws, particularly the GDPR, which is applicable within European Union and for EU citizens data elsewhere. Without a lawful basis, the processing of personal data would be illegal. The GDPR lays out specific lawful basis to ensure that personal data is processed transparently and that individuals' rights and freedoms are protected. Let's understand the lawful basis for processing personal data using some example. Simple example. The first one is consent. The individual has given clear and specific consent for their data to be processed for one or more purposes. That means it allows individuals to selectively give or withhold their consent based on their comfort level with each specific data processing activities. The consent should be given freely, and the consent should be informed, and it should be specific, unambiguous, and reversible, right? The example is a user signing up for a newsletter and ticking a box that says, I agree to receive marketing emails, right? The company can now lawfully process the individual's personal data for this specific purpose, because they have obtained clear and explicit consent from the user. Next, contractual necessity. The processing is necessary for a contract with the individual, or because the individual has asked for something to be done before entering into a contract. For example, a bank needs to process an individual's personal data to open a bank account for them. The bank can now lawfully process the individual's personal data for this specific purpose because it is necessary to perform the contract between the individual and the bank. Right. Next, legal obligation. The processing is necessary for the data controller to comply with the law, excluding contractual obligations. For example, a bank reporting suspicious financial transactions to authorities as required by anti money laundering laws. The bank now lawfully processes the individual's personal data for this specific purpose because it is necessary to report under this legal obligation. Right? Next, vital interest. The processing is necessary to protect someone's life. For example, a hospital needs to process an individual's personal data to provide life saving treatment. In this case, the hospital can lawfully process the individual's personal data for this specific purpose because it is necessary to protect the vital interest of the individual. Next, public interest. The processing is necessary to perform an official function or task that's in the public interest. The example here is a government agency processing personal data for issuing a passport or driver license. Next, legitimate interest. The processing is necessary for the legitimate interest pursued by the organization or a third party unless these interests are overridden by the individual's interest, rights, or freedoms. For example, a retailer processes an individual's personal data for the purpose of sending them targeted advertising based on their shopping history. The retailer can lawfully process the individual's personal data for this specific purpose because it is necessary for their legitimate interest as a business. And the individual's interest or fundamental rights and freedoms are not overridden. So, here, how can a company rely just on legitimate interest as their lawful basis? My next video about legitimate interest assessment that includes purpose, necessity, and balancing test. So please stay tuned. All right. Next, lawful basis for processing sensitive personal data. Let's understand what are the lawful basis for processing sensitive personal data. The number one is explicit consent. The individuals gives explicit permission for their processing of their personal sensitive personal data. For example, a patient agreeing for their medical history to be included in a research study. The second one is employment, social security, and social protection. If the processing is necessary for employment laws or where it is necessary for social security or social protection law. For example, an employer processing data about an employee's health condition to ensure workplace safety or to provide appropriate workplace accommodations. The third point, vital interest, where the data subject is physically or legally incapable of giving consent and the processing is necessary to protect their vital interest. Right. The example, a hospital sharing patient allergy information with a specialist when the patient is unconscious. And fourth point, public interest, public data. If the information has already been made public by the data subject. For example, someone publicly shares about their own health condition on a public forum and a researcher cites it in a study through ethical consideration still apply, though ethical considerations still apply. Fifth point, legal claims. If the processing is necessary for legal claims or judicial acts, for example, processing personal data to establish, exercise, or defend a legal claim in court. Sixth point, made public by the data subject. The personal data in question has already been made public by the individual. For example, a celebrity openly discusses their medical condition in a public forum. A news outlet writes an article discussing the condition and the celebrity's experiences. The seventh point, not for profit bodies. Not for profit organization processing data of their members or those with regular interactions related to the organization's activities. For example, religious non-profit organization processes data on the religious beliefs of its members to organize faith-based events. Seventh point, substantial public interest. Processing is necessary for reasons of substantial public interest based on union or member state law. For example, a government body processes data on citizens' ethnic backgrounds to monitor and promote equal employment opportunities in public offices. Eighth point, public health. Necessary for reasons of public interest in public health, such as protecting against cross border threats to health. For example, during a pandemic, health authorities process health data from patient to track the spread of the disease and implement public health interventions. Ninth point, healthcare. It is necessary for health or social care purposes, and processing is done by or under the responsibility of a health professional or another person subject to a confidentiality obligation. For example, a patient's medical history is processed by their doctor to provide the best possible medical care and advice. 10th point, archiving research and statistics. It is necessary for archiving purposes in the public interest, scientific or historical research or statistical purposes. For example, a research institute processes anonymized health data from patients over several decades to study the long term effects of a particular drug. So, the conclusion is selecting the right reason to process data is crucial. It helps companies follow rules and protect individuals' information. By making the right choice, companies show they are trustworthy, right? In today's world, handling personal data correctly is a sign of respect and responsibility. Thank you for watching. Please subscribe and stay tuned for more videos on data privacy and protection. Bye bye.